Major breaking news, and it's not good, out of the United States Court of Appeals for the Fourth Circuit in Maryland. The Bianchi quote-unquote assault weapon case has been en banc. The only good news out of this at all, and there really is no good news, is that this is exactly what I predicted over a month ago, and I told all you that I thought that the game, the dirty pool in my opinion, that the Fourth Circuit Court of Appeals judges were playing as one of the worst Second Amendment courts in the country, refusing to respect the Constitution, refusing to respect the text and the history of the Second Amendment, was playing a game by trying to prevent the three-judge panel from issuing a favorable ruling knocking out the quote-unquote assault weapon ban of Maryland. And I predicted the reason why it was taking so long is there were shenanigans going on in the Fourth Circuit among all those anti-gun judges to prevent that panel decision from being issued. And indeed, today, unfortunately, I have been proven correct. My prediction has been proven 100% correct. The Fourth Circuit Court of Appeals has just issued an order deciding to en banc the case, en banc the Bianchi case before the panel could even issue a decision which was likely going to be in favor of the Second Amendment. Dirty pool, in my opinion. Stay tuned. We're going to break this down in 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in 2 separate Gundy categories for 2024, top male influencer in the Second Amendment space, as well as top voice of the Second Amendment. I'm proud to be nominated and a top 5 finalist in both categories. Let's see what happens in Las Vegas later this month. All right, folks. Anyway, huge news, disappointing, and it's actually making me very angry. I hate to report this sort of thing, but I have a duty to you to call it as I see it. But you may recall that the Bianchi versus Frosch case, which is now the Bianchi versus Brown case, out of the United States Court of Appeals for the Fourth Circuit dealing with the quote-unquote assault weapon ban by Maryland. This was argued over a year ago. And everyone has been talking, why Mark is this case taking so long? And I was asking the question myself, why is this case taking so long? It's a very straightforward case. Semi-automatic rifles are obviously in common use. There's tens of millions of these things out there. I mean, the National Shooting Sports Foundation just issued a study the other day that says there's upwards of almost 30 million of these according to their own data. Okay, and we know there's a lot more. That's why the anti-gunners don't like them, because there's so many of them. Nevertheless, we have the semi-automatic rifle ban in Maryland for all intents and purposes. It was argued, I think, in November of 2022. We waited over a year. We're still waiting, and I predicted in November, and I'm going to put a link to it. I'll play the clip. I predicted that I thought what was going on, because the United States Court of Appeals for the Fourth Circuit is literally one of the worst courts when it comes to our Second Amendment rights. They're up there with the liberals in the Ninth Circuit, and they're up there with the First Circuit Court of Appeals out of Boston. These are just absolutely horrific, anti-constitutional, anti-Second Amendment courts. Keep in mind that the Fourth Circuit out of Virginia and Maryland is right there in the heart of the deep state, the security state. So you know what all that means when it comes to respecting citizens' rights and the right to keep and bear arms. I'll let you do your own inference from that, I think, but you understand exactly what I'm saying here. So anyway, it turns out that the 3-judge panel I listened to the oral argument over a year ago. It looked to me that was going to be a favorable ruling in favor of the Second Amendment, knocking out the Maryland quote-unquote assault weapon ban as unconstitutional under the Second Amendment, which is a no-brainer ruling. Virtually everyone watching this channel could probably write this opinion and nail it, right now, this weekend. But it turns out that the Fourth Circuit panel was likely going to, this is my guess, the Fourth Circuit panel was going to do exactly that, and the Fourth Circuit internally en banced it. Specifically, they have decided to prevent that 3-judge panel from issuing the ruling. And based upon what I heard during that oral argument, it was going to be at least 2-1, maybe 3-0, but probably 2-1. I think one judge seemed kind of anti-Second Amendment. Nevertheless, it was going to be a victory for the Second Amendment. Now that will never be issued because, according to what has just occurred, something that I predicted I thought was occurring back in November. Specifically, the Fourth Circuit Court of Appeals internally, without anybody asking for it, has decided to en banc the Bianchi case internally and prevent the panel from issuing its decision, likely because they didn't want a good Second Amendment ruling to come out of the Fourth Circuit. Here is what the order says that was just released. I'll put a link to it down below. It says, quote, a majority of judges in regular active service and not disqualified having voted in a requested poll of the court to grant rehearing en banc. Now, here's the thing. Who requested the poll of the court to grant rehearing en banc, and why did they do it? Let me tell you what I think happened. It was a 2-1 decision in the panel, and the dissenting judge decided to be angry and bitter about having to respect the Second Amendment, decided to internally ask for a poll of her fellow judges, knowing that there are terrible anti-gun judges is the clear majority in that U.S. Court of Appeals. So the bitter, angry, dissenting judge in the panel is my guess is the person that asked for a poll of the rest of the court, knowing that that would prevent the 3-judge panel ruling in favor of the Second Amendment from being issued. This is my best speculation. We will see when this decision is ultimately issued, which will likely be over a year from now, because what's happening, in my opinion, this is going to sound terrible, but I call it as I see it, whether it be a Republican, a Democrat, a liberal, conservative. If I see something that I don't like, I'm going to tell you. Okay, let me tell you what I think is really going on here. It is pretty clear to me that the U.S. Court of Appeals for the Fourth Circuit does not want the U.S. Supreme Court to rule on a semi-automatic rifle ban until the current composition of the Supreme Court changes. They want Clarence Thomas or Justice Alito to leave the court in some way, or they want to be able to have the Democrats in Washington expand the court to add a bunch of progressive liberals like Brown Jackson, who will simply vote as a politician in black robes in favor of the progressive left-wing causes of America, which would include, of course, gun control. And the best way to make sure that that happens is the en banc court has now taken over the Bianchi case, and they're going to sit on this. You see what happens here. They're going to sit on this case for well over a year, and they're going to hope and pray that at some point between the time they decide the case and the time it goes to the U.S. Supreme Court, that the Supreme Court's composition has changed in a way that's favorable to the gun controllers, i.e. either Justice Alito or Justice Thomas leave the court. That is clearly what they intend to do here. It is, a blatant game, a blatant power grab. There's no other way to call this anything but what it is. This is not treating the Second Amendment like any other right. They are singling out the Second Amendment for inferior secondary and tertiary treatment as if it's not a right at all, and thus it's a privilege in their mind. That is what, by all intents and purposes, their action speaks of right here and right now. Now, just to show you the minor, I don't want to call this good news, but just illustrative news, that my goal is to make you the smartest person in the room, no matter who else is in that room when it comes to our Second Amendment rights, even if sometimes there's news or information that we're not happy with. But we have to accept that sometimes bad news and bad events will occur, and we have to make the most of them and do the best with them, because we are in a war that is going to go beyond all these various battles in the courts and more. So we have to just recognize that we're in a long slog here, whether we like it or not. We have to keep fighting in all quarters, the legislators, the courthouses, the court of public opinion, and so on. Nevertheless, I do want to show you, this is my prediction that was back in November, over a month ago. I predicted that this is exactly what the Fourth Circuit Court of Appeals was going to do. And just so you can remember, for those of you that watch the Four Boxes Diner, you would have known this, and you would have talked about this over a month ago. You would have seen this coming long before anybody else did, except, of course, the judges within the Fourth Circuit that were playing this game. Okay, so with that said, let's roll the tape. I think I have figured out something. Now, I don't have any inside information here. I can't be certain. But there's a mystery going on with the Second Amendment involving the quote-unquote assault weapon ban case arising out of the state of Maryland, dealing with bans on semi-automatic firearms and the like, in the case known as Bianchi. It was heard by oral argument in December, specifically December 6th, 2022. Because a lot of people asked me about this, I decided that I would take a look a little bit more seriously as the time has been ticking. And I think I figured out what's going on here. I think that the Fourth Circuit Court of Appeals is playing games. So I suspect what may be happening here in Bianchi is that a 2-1 decision had been drafted or had been voted on in favor of the Second Amendment. I suspect that the judge that's playing this game, this is my speculation, is Judge Stephanie Thacker, because she was definitely anti-gun. So I have a feeling, and this is my speculation, that Judge Thacker has gone to the rest of the Fourth Circuit and got them to internally en banc the Bianchi case, and now the entire Court of Appeals for the Fourth Circuit is going to issue an anti-gun, anti-Second Amendment ruling. All right, folks, well, there you have it. I suspect it's going to be well over a year before we have a decision out of this en banc court in the U.S. Court of Appeals for the Fourth Circuit. I think it's absolutely pathetic. I think this is not how the rule of law works. I do not think this is a fair system of justice down there in the Fourth Circuit Court of Appeals. I think it is absolutely an embarrassment to the rule of law and to federal judges everywhere. So I hope other federal judges, including the Supreme Court, take notice of this kind of behavior, because I can assure you that the Second Amendment movement, which consists of millions and millions and millions of law-abiding and tax-paying Americans, are recognizing what's going on in some of these courts, and it will not be forgotten. Okay? All right. Well, there you have it, folks. I hope you learned something here today. I wish I could bring you better news, but sometimes we have to just deal with the news and move forward, and that's what we have to do here with the Bianchi case, U.S. Court of Appeals for the Fourth Circuit. I will keep you, I will keep you apprised as things develop. Don't forget to follow me on X at 4 Boxes Diner, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.